last occasion, were on record. We sent Advocate Tefo to deal with the matter on the day in question.
My recollection is that at the beginning of this matter, Advocate Tefo approached together with everyone else and informed that Titi Tovane are his instructing attorneys. He further went on to say there will be times when he will be occupying the podium on behalf of accused number 1 and 2, and there will be times when Mr. Tovane will be the one doing that. And indeed, it happened from time to time. One of the days, Mr. Tovane yourself approached and informed court that the next coming date, I will not be able to be there. And the court noted. And indeed, on that following day, Mr. Tovane was not there, and we proceeded. Mr. Tovane would come in and out from time to time. And on the day this matter was last postponed, or before that, there were other days when we just saw Mr. Tefo around. There was no explanation from Mr. Tefo, and there was no explanation when Mr. Tovane reappeared. So in my observation, Mr. Tovane came and went as he wished. That is what was happening. On the last day this matter was postponed, Mr. Tefo, or Advocate Tefo, was alone, and he withdrew. There was no pre-warning that Mr. Tovane will not be around, and in withdrawing, Mr. Tefo said nothing about Mr. Tovane. I sat and imagined that because Mr. Tefo has an instructing attorney, it might be that on the following day or very soon thereafter, we will hear from Mr. Tovane what is the way forward. Legal representation is a constitutional right of every accused person. And when Mr. Tefo withdrew without saying anything about Mr. Tefo, it became incumbent upon me as a judicial officer to remind the accused that they still stand vested with the right of legal representation. And indeed, I went on to explain that. And in that process, I wouldn't read any error. If there was an error, it's an error of an officer of the court giving the court the impression that he will be around when this court serves before court, and willy-nilly staying away when and if he feels like doing so. That is the error. There would not have been any other error. And if indeed it was postponed for purposes of accused number 1 to 4 to acquire legal representation under circumstances where Mr. Tovane is still available to do that, there was no need for any hullabaloo to arise from that. It was a matter of simply informing all those who need to know that Mr. Tovane, despite staying away without saying anything, is still available for purposes of this of this case, which is still the case. If Mr. Tovani is still available for purposes of number 1 to 4, it's a matter of informing whoever needs to know that Mr. Tovani is still available for purposes of this case. For us to try and read an error, I think it's misstating facts. And it also sounds like a cover-up for something, which is staying away without noticing that I will not be there. Because if you are there, once you are there and we start a trial, each time you absent yourself, you are duty-bound to inform whoever has to know that I will not be able to. And if indeed you did so and you did not inform those you needed to inform, it will not be right to come back and start speaking about errors. There is no error that happened here.
As the court pleases, maybe this is an issue of interpretation. I said it is an error to postpone for them to get a new representative.
It was for that purpose. I am the one who told them, your advocate has withdrawn. You still have the right to be legally represented. If they knew you to be still around, it was also incumbent upon them to say, no, Mr. Tefo has withdrawn, but Mr. Tovani is still around. Not only them, like I said before, it was incumbent upon Mr. Tovani to say, I hear that on the day when I absented myself from court at will, at my own will, I hear that the advocate withdrew. I am still there, Mr. Baloi, Ms. Mshololo, I'm still there. And please inform whoever has to know. And nobody would have had this conversation, nobody.
As the court pleases, the Honorable Court must note that in this court, proceedings were not, the climax was not in a proper way. Even on the climax of the proceedings were not in a good way. Even on the day when Advocate Tefo withdrew, before we came to court, I had to attend another matter, as even the court reminds me that I did inform the court that at several times I won't be available.
No, it can be. If I may finish, it can be several times. You must inform whoever must know each time you are going to be away from the proceedings. That's how it should be done. No other way. Climax or no climax.
If I may proceed and finish my statement. On the day Advocate Tefo withdrew, I was not in court, which that I concede. The reason being that I had communication with him with the manner in which the proceedings were going on, and were differing. Even if there's history in this matter that in this court during the proceedings, whenever there's a conversation between the court, the Honorable Court, and the advocate, I tried to intervene, but now we were painted with the same brush by the Honorable Court to say, you too, which to me, it was not proper because I was trying to intervene. Even if on that question, on the day when advocate withdrew, if there was something wrong happening, I was going to intervene. But now, because of what happened in the past, hence I had to attend another matter, and he comes alone in court to deal with the matter. In any event,
so because of this climax or the situation in court, you dumped number 1 to 4 because you didn't like what was going on in court, and you expected the court to figure out that despite the withdrawal of Mr. Tefo, there will be a day when you come. And if that be the case, it cannot be a basis upon which you come and say there was an error. There was no error. There was no error here. I, as the responsible presiding officer, was making sure that because Mr. Tefo withdrew unceremoniously, even derobing in court and leaving without saying anything, I was making sure that the right of legal representation of accused number 1 to 4 stays protected. And if I did so and you were poised to come back as you did now, we cannot come back and say there was an error. We can only come back and say, I am here, let us proceed. I suspect I wouldn't even have raised the matter of you staying away without saying anything. You are an officer of the court, Mr. Tovani, for God's sake. And you know what is the right thing to be done about absenting oneself from court or attendance or whatever. Even if you need to step out, you know what should be done. That is exactly what you did not do. And all I'm saying now, I'm saying, let us not talk of an error. Let us talk of the fact that you are back, to which I have no qualms, and that we are proceeding.
As the court pleases, my instructions from the clients are that I proceed to deal with the matter.
That is very welcome, very, very welcome. It sort of circumvents other processes that would have had to happen before we proceed. In your absence, we even mooted the issue of availing transcription, because you'll remember that we took a decision back that all proceedings will be, there will be transcription for all proceedings on a daily basis. We would have had to make available those transcriptions for whoever would have had to take over after Mr. Tefo.
Furthermore, Your Worship, my Lord, I did communicate with my colleague from the state that we intend to apply for bail for accused number 2. And it will be better if we arranged with them a date before the 5th of September, so that we cannot interrupt the trial and deal with the bail and finalize it.
The admittance to bail is a right available subject to the law. It is addressed through case law. It is addressed through the Criminal Procedure Act. And there is nothing, there's nothing untoward about it. It's up to you and your client to see how to stage. And in this division, and I think in South Africa and even other jurisdictions in other countries, bail applications are treated as urgent.
I agree with the court.
And it is not dependent upon the whims of the presiding officer or whoever, or the registrar or the DJP or the JP. It is an application that must be made, and once made, or once indication is made that there is a need for an application for admittance to bail, the agency kicks in, and we have to find time. We have to find time. We have to gather, because of past experiences. Let me mention it now. We may even have to go and approach, or the three of you may have to go and approach the leadership of this division for purposes of placement, because I think it would be unfair to say it to you, but for purposes of public knowledge, we should not pretend this is the only case in the Republic of South Africa. When this case is not here, there are other people.
As a court,
that is why from time to time, when the need arises, we notify and we say, let us meet for this and that purposes. And of late, where we cannot meet physically for that, we even arrange to meet virtually for that. But all I'm saying is that bail, application for bail is a right available at the disposal of everyone who needs to apply. And I need not outline to you. If it was your clients, I would outline what should happen, the ABC of it. So you should go ahead. If that be your instruction, go ahead and see what you need to do about that kind of an application. I think I don't know if, well, from here I can't see if my secretary is here. But I will inform him if he's not here, that there is that eventuality. In this case, because of the public interest there is, where we would have been saying ordinarily there is agency, I would say with emphasis there is agency. Because as you know, the denial or granting of bail impacts on many other people and on many other processes. So that is my attitude.
Thank you, my lord. My last submission is that I request that when we adjourn, the prison officers allows me 30 minutes to take instructions with regard to the bail on only accused number 2. As court pleases.
Yeah, as you know, my attitude is you should be able to consult all the time when you have a reasonable request to do so. When I asked my secretary this morning, he told me that the delay is because you need to consult, and I was a bit surprised because in my book it was always possible to do it this way, for us to come and sit and postpone this matter, and you do as you are doing now, and correctly so and rightly so. You request that you be given time to consult, and as I sit here, I don't think I even need to issue an order. It's in the morning now. Accused persons can only be taken wherever, home or to prison, later in the day. So it is my imagination that when you want to consult, it will be touch and go. If it doesn't pan out that way, I will advise that your 2 colleagues be informed immediately, and that I be made to know immediately that you are confronted with hurdles in your strive to consult your clients.
As a court pleases.
Mr. Baloyi, you said you want. Oh, before we do that, I don't know if Advocate Nchololo has anything to say as of now.
No, my lord, I've got nothing.
As a court please, my lord, we can then adjourn the matter to the 5th of September for the continuation of the trial. I understand from our learned friend that he'll consult after the matter has been adjourned. So it's not necessary for now to adjourn and then to come back. So we can already at this stage adjourn the matter for continuation of the proceedings. All the accusers are in custody. I confirm
Before I do that, I think there's something brief that I need to spell out. And I think it's also, it might be a bit unfair for advocate, for Mr. Tobane. My sense, and a very strong sense, is that we are running an open court. In other words, anybody can attend, anybody can have access to what is happening in court. how should I put it? There are times when I'm getting communication, Mr. Tovane. There are times when I'm getting communication about this case. And I am getting to learn about the communication, sometimes on billboards. You are driving wherever and you see a placard of a particular publication with a heading which informs you about what is next to happen. And if it didn't happen repeatedly, I would still be had to be saying, is that in the same case where I'm involved? Because I'm learning about some development from a billboard, driving somewhere, home or church or wherever, and then you learn about those things. And when that communication arrives, you realize it is, I'm saying it also because you are the instructing attorney, you realize that it is also addressed to you, I mean me. And I don't want to get into that. I think it would not be the opportune time. And you wonder, is the court now a pen pal of the legal representatives, or what is happening? But I don't want to get deeper into that because it might turn out very unfair against you. But I needed for you to hear this because you are the instructing attorney. And so I felt that I should say this. In those communications, there are many issues that we should not get into. Some of them are very interesting, very, very interesting. They are about whether, they are even about one's faith, where you place your faith and so forth. Some of us have a physician. I have a physician, and the matter of my physician is not the problem of anybody. It's even irrelevant here, but because of what is happening, one needs to say it out and loud. I have a physician called Jesus, and he needs no augmentation. But it might not be a story for today. Even before I came here, I consulted my physician. When I leave here, I will consult my physician, but it's nobody's business. And I should also not make my physician anybody's physician. And that physician does not make me better than other people. It makes me better than myself by the day. I needed to say that.
Yes, so, Your Lordship, if I might just say something.
Yes.
If the court can remember, I hear the court talking about physician.
Yes.
If the court remember,
Yes.
the advocate who was appearing in this matter
Yes.
for 124
Yes.
has withdrawn.
Yes.
When he also talks about whatever he's talking about after he withdraw, then it's not the instructions of the attorney. Then it's not part of this matter anymore. Whatever he says, he says out of his mind.
I needed to hear what you are saying.
Thank you.
I needed to hear what you are saying.
Nje ukuthi lokho esekushiwo kuqalile ke wasukuma uadvocate Baloyi echaza ke inhloso yokuthi sihlangane namuhla ukuthi icala ke lahlihlisiwe nge-12 zika July hlehliselwa ke namuhla ngoba ke uadvocate ke wathatha isinqumo sokuthi ahoqe kodwa ke icala lona ke bese linelanga elahlehliselwa lona ilanga lange-5 zika September. Nanje ngoba ke yena ke uadvocate for esewahoqa ke ngoba ke kuthiwa ke namuhla kufanele ukuthi inkantolo izozwa noma yazi ke ukuthi ummeli wenu noma abameli benu kuzokwenzekani ke uqhubeka uyaphambili wasesukuma ke uTT Thobane ekuyena ke ummeli wenu echazela inkantolo ukuthi cha ukhona ke namuhla kodwa ke futhi ke uzoqhubeka necala kodwa ke wakusho lokho ke ngokuthi ke ayichazele inkantolo ke la kuye kwavela khona ukuthi kube khona ukukhulumisana phakathi kwenkantolo kanye naye ke ukuthi echaza ukuthi kwaba nephutha ngelanga elingaphambili ngelanga lange-12 kathi ke uadvocate for ehoqa la ecaleni ukuthi ke icala limiselwa namuhla ukuthi ke nizothola ummeli omusha noma abameli abasha ila khona ke inkantolo ibisimchazela khona ke ukuthi kwakuyini imbangela yokuthi kwenzeke lokho ngoba wayengekho yena ngaleli langa futhi akukho okwashiwa uyena uadvocate for ukuthi yini imbangela yokuthi ke uTT Thobane angabi khona inkantolo yasimchazela futhi ke ukuthi ke yinto ebivamisile ukuthi yenzeke la enkantolo ukuthi uma ngabe efisa yena ke angabi khona engachazelanga umuntu noba omunye ummeli kaMmangalelwa wehlanu noma uadvocate Baloyi noma inkantolo futhi nangaleli langa ke inkantolo ayizange nje ichazele lutho ke kodwa ke lolo daba ke lube selubekwa phansi ngoba inkantolo ithe nje khona nje efisa ukuthi kwazi yona ke ukuzwa ukuthi ukhona futhi uzoqhubeka ke ilokho ke akushilo ukuthi ngempela ke abamangalelo umangalelo wokuqala ukuya kuyena umangalelo wesine bashilo impela ke nake ukuthi isifiso sabo ukuthi yena ke aqhubeke ummeli wabo wasechaza ke nenhloso abanayo ke yokuthi babe nesicelo sebail abasenzayo basenzela yena ke umangalelo wesibili nala inkantolo ithe khona ke futhi ke bethi bafisa ukuthi lokho bakwenze ngaphambi kwaleli langa leli icala elizothi liqhubeke ngayo ilanga lange-5 zika September inkantolo ithe ayinayo ke inkinga kulokho uyazi ke yena ukuthi yini ekufanele ayenze nekufanele kulandele ukuthi benze ke kona ke lokho nokuthi ke bazoya yena ehambisana nabanye ke ama advocate lana amabili ke noma beye kubona ke abahola inkantolo lena bakhulumisane nabo bezwe ukuthi kuzokwenzekani ke ngalelo langa lelo.
Please rise.
No, abamangalela bodwa hlala phansi.
You have heard what is to happen.
Nikuzwileke ukuthi kuzokwenzekani noma okuzoqhubeka.
Based on what you have heard, this case is postponed with you in custody to the 5th of September 2022 for further hearing.
Njengoba senizwileke icala lona lihlehliswa ke lihlehliselwa i5 zika September kuwona lonyaka ila lizoqhubeka khona ke ukuthi liqule icala.
But I've been told that there are some amongst you who aspire to apply for bail.
Inkantolo itsheliwe ukuthi bakhona ke kinina abafisayo ukuthi ke benze isicelo sebail.
That is a right available at your disposal. It's a constitutional right.
Ilungelo ke eninalo ke lelo ngokwayo umthetho sisekelo.
Arrangements, I want to imagine that arrangements, unless something changes, arrangements shall start forthwith to find time to entertain such an application sooner rather than later, and most preferably before the 5th of September.
Inkantolo icabanga ke ukuthi kuzoqala ke ukuthi kulungiselelwe ukuthi leso sicelo leso ke ngaphandleni kokuthi ke kukhona ke okuzoshintsha, futhi inkantolo icabanga nomfisa ukuthi lokho kuzokwenziwa ngaphambilini kwaleli langa lange-5 zika September.
Anything else?
None, my lord.
Lastly, Your Lordship, I would like to apologize that if I created the impression that I don't respect the court by staying away while my advocate was here and attending other matters, then I render an apology on that one.
I think I should say here and now, Mr. Tovani, the apologies is accepted. I want to take it as an officer of the court. You indeed didn't mean anything adverse. But also maybe what you are saying, that this case is traveling on a gravel road, and maybe that is causing some of the hiccups that we are having.
Yes, of course.